Welcome to our Tech Conversation series. I'm so happy to have Salome Viljoen with us. She's one of the most interesting scholars, I think, working in the information policy and law space, data governance. And so when I first heard Salome give a talk on this paper, I was just really happy and intrigued, and I'll introduce Salome in a second, because, I think it speaks so much to the frustration that so many of us have with this sort of tech-lash, anti-tech concerns about data aggregation, that were especially kicked off with Shoshana Zuboff's Surveillance Capitalism book, and yet at the same time, this sense that there's a failure of law and policy to actually address some of the socio-political concerns that have been identified. And I think here in the US, many of us look to Europe, which has a lot more privacy regulation and data regulation, but it's also failing to address some of these issues. And so I just so much look forward to our conversation about, what's at the root of the disconnect between the harms that we identify and the sort of policy tools that we reach for. So Salome is an academic fellow at Columbia Law School and also a fellow at the Berkman Klein Center for Internet and Society. And she's interested in the information economy and inequality writ large. And I'm hoping Salome has a background in feminist theory and feminist legal theory, so maybe we'll get to that. And so, I think in general, what I found so compelling, Salome, was how you're helping us think about how law and policy should be shaped to increase democratic control over data collection. And so I want to start our conversation just by, I don't want to summarize your work, and I'm hoping you can talk to us about what you mean by democratic data, but let me just start us by saying that, we use a lot of metaphors here, and we talk about, when we talk about data, right? We talk about data extraction and data as a resource, and we talk about the quantified self and data as an extension of self. And you talk about data and datification as social relations, and so that I hope we'll get to right away. And so, and I think what you identify is that our current discourse about data focuses on data as property or data as dignity, and maybe you can tell us about that. And because of that conceptualization, or independently of that conceptualization, we lean on contract law and consumer protection as our tools to control excessive data collection. And so you tell us that those are incomplete conceptions, and those are insufficient tools. And so I hope I will turn it over to you now to comment on that and maybe lead us in with an example of what you mean by data as social relations.
Yeah, thank you so much. And it's a real pleasure to be here with all of you. And thank you, Ellen, for that wonderful introduction to me and to my work. So I think as you kind of pointed out or teed up there, this piece is really, the beginning of my entire research agenda on these sets of questions. And it was really sort of motivated by a desire to do two things. So one is to take very seriously what I call social informational harms, the set of sort of social and political claims that people are starting to make with respect to information. So it's not purely this kind of personal, like I'm being watched and I don't like it, but the kinds of claims people are making about technology sort of posing a threat to democracy and undermining our ways of living together, or sort of creating a lot of these, what we traditionally think of as sort of social and political claims of harm or of oppression or of discrimination or of violence even. So to take those seriously on the one hand, but also to develop a theoretical account of what we're doing in the law when we give people interests in information that also leaves room for us to say, leaves room for sort of like a range of options that aren't the law can tell us yes or no to data collection, but to sort of develop a question or sort of interrogate a set of questions about how to appropriately allocate as a social resource this incredible analytic set of tools that we have and ways of knowing one another that we kind of have at our disposal when we think of sort of mass at scale data collection and the access to computational tools to make sense of ourselves. And so, you know, I think that the motivation for the theoretical work was really to say, you know, what we're really doing when we do all of this mass data collection is developing our sense of social knowledge, who we are, how we make sense of how we interact with one another. And wouldn't it be great if we sort of allocated this incredible social resource less to knowing a whole lot about my shoe purchasing preferences, and maybe more on actually a lot of the most pressing social and political challenges that we face. We know a lot more about how we're currently allocating this kind of analytical set of resources about my shoe preferences than we do about my CO2 emissions, or that we do about how I move around the city and how I might move around the city in a way that is maybe more environmentally effective, or you know, any number of kind of questions there. I like using the environment because it's just such a clear understudied kind of area with respect to our social data. So that was kind of sort of the motivation. And social relations, I think for me, play a really important role in helping to say, when we think about information flows, not as a thing that I own and can say yes or no to, or an extension purely of me, Salome, and a woman on an island, and I can grant people access to my island and I can kick them off of my island. But to say no, I mean, the way that information is socially useful, is economically valuable, why we collect it to begin with, is not so that we can understand a bunch of things about Salome that we stick in the Salome folder, but to understand how I, Salome, am like other people in ways that are meaningful about me and that can then be used to predict or sort of guide decisions about me. And that's kind of on the one hand, totally obvious to all of us who work in this space, but on the other hand is a really profound departure in the law of how we think about information. And when we think about information as kind of materializing my social relations, so how I as a person am constituted by all of my social categories and all of the ways that I'm like other people, we can, one, both make sense of a lot of these kinds of claims that people are making about why information collection is so harmful. And also, two, understand that, you know, just like a lot of our analog social relations are currently marked by oppression on the basis of group relations, the appropriate goal is to not get rid of our social relations, but to make them relations of equality, develop our social relations as they're materialized in data flows in a way that can kind of empower us to come to forms of knowledge and to make the kinds of collective decision-making processes that we can only make together. We can't make them alone. Mm-hmm. And I'm happy to drill into all kinds of examples if you'd like, but I've been talking a while, so I want to give you.
I want to start. Let's try to bring this down to earth a little. Mm-hmm. You have your paper this, and I think, you know, shorthand for this is all my individual data is, if you've got nothing to hide, you don't care about data collection, which was, you know, sort of the, let's say it was at the core of what we call a privacy paradox that was developed, you know, I don't know, 10 years ago, whatever, which was, you know, this sense that, well, people really don't care about their private. First of all, formulating this problem as a privacy problem, which I think you and I both agree that that has sort of cornered us into a way of thinking about data collection, which was very individualistic and played into this paradoxical trope, right? Which was that, you know, we nominally care about privacy, but if you ask anybody what they're willing to trade for their data, it's very little because they feel they have nothing to hide. And I think you're calling out that even if that's true, right? And I think that question is, that whole framework is kind of a canard because people don't really necessarily understand how their data is being used in ways not to expose or embarrass that things that they're trying to hide, but in ways that target them for, jobs or limit their ability to get, resources and target their information environment, micro-target them, etc. But you're pointing out something deeper, right? So that's the first step, right? Is that the materializing yourself through data may have implications for you that you didn't fully comprehend and wouldn't consent to. But you're making the deeper point, right? That even if you would consent to it, it has spillover effects. And I really want to kind of get to maybe through an example what you mean by these horizontal data relations, but we might also call spillover effects or externalities, of data collection about you. And I thought maybe we could do the tattoo example.
Mm-hmm. Yeah. So I'm happy to kind of jump into the tattoo example. So the tattoo example that I use throughout my piece is I kind of make up a company that's kind of based on Clearview AI. It's called Tattoo View AI in my paper. But instead of doing faces, what Tattoo View AI, what the image data that they collect is all about tattoos. So this is also based in a real world thing, which is that law enforcement agencies do have tattoo databases. They partner with private organizations like Palantir to access and analyze tattoo databases. So it's a hypothetical example, but grounded in real world goings on. And so in the paper, I use the example of—
interrupt you for 1 second with something
sure,
that
yeah.
I think this is so interesting about specifically the tattoo example, because it also gets at the whole public-private distinction which we're wrestling with, right? In the
Absolutely.
same way that that Clearview AI and facial recognition, right? Like but it's public, and it's your tattoos. That's the whole point, and if they're right on certain parts of your body. But at scale, they have a different effect.
Yeah, absolutely. And so in the paper, I have the example of a person who has the tattoo, Adam, who is a social media user of Tattoo View AI, and he uploads a picture of his tattoo. And kind of the normal way that we would make sense of this in the law is we would say, well, did Adam consent to uploading his tattoo? And does he kind of agree with all of the uses potentially that this tattoo image data could be used for? And in this scenario, I say that Tattoo View AI has partnered with local law enforcement agencies, and they're now using all of this tattoo image database data to identify which tattoos are likely signs of gang membership. And they use this kind of the analytics that they've gotten access to from the company to identify that someone who has that same tattoo as Adam named Ben is maybe a gang member, and they stop and detain and question Ben on the basis of this gang membership. So if we get back to Adam, again, from a property or sort of a classic kind of framework of like, how would the law decide whether or not this data flow is okay or not okay? We would ask, did he consent to this data flow? And maybe we would even say from like a robust dignitarian thing, does he agree with the way that this data flow is being used to sort of target and detain other gang members? And so, maybe under a dignitarian kind of robust data protection thing, Adam would have not just like whether or not he consented to the data being collected, we would also have some downstream control over how that data is used. And he could say potentially, no, I don't want this to be used to detain other people on the basis of that tattoo who we think might be gang members. And so, that would potentially prevent that tattoo data from being used that way. But what if Adam is actually a reformed gang member, and he actually feels very strongly that, being in the gang was really harmful for him in his life, and he actually actively wants to share his tattoo data with law enforcement to sort of stop other people with that tattoo and sort of prevent gang membership. Now, the real consequence that this had for Ben, who is being detained because he shares this tattoo with Adam, is not represented in the legal relationships between Adam and Tattoo View AI and the sort of partnership with law enforcement really at all. And so what I use that example to show is that this tattoo image data is Adam's data, But in the way that it's being used, in the way that it's being made sense of, it's also in a very basic way data about Ben. And Ben's interest in that tattoo image data is not really represented anywhere. And so this kind of has like a few practical upshots, I think, for me. And that is that, first of all, and I'm not the only person to say this, but kind of, Ellen, to get back to your original point about the privacy paradox and all these conversations about consent. In contract law, it's kind of taken as kind of a basic view that we can't consent on behalf of another. Consent is a thing that I can give with respect to myself. But because of how the data economy functions, because of how data imparts meaning, we are, even under best case scenarios, if we gave the most meaningful, robust consent we could, we are effectively consenting on behalf of another all the time. So even if we were to resolve, and I used to be a behavioral economist, I used to be a health economist, I have all sorts of qualms about how those studies were set up kind of empirically. We can kind of empirically and methodologically critique privacy paradox studies, but even if we put all of that to a side, as a conceptual matter, what we are doing in the privacy space all of the time is we are consenting on behalf of another. And that's just not what contract law is about. That's not the right kind of framework or approach to be taking here.
Yeah, I mean, so an example like this that people are probably familiar with is 23andMe genetic information, right?
Yes.
So, and I just heard, an interview with Wojcicki, the CEO of that, and she was very insistent that all the data that they gather for their pharmaceutical development, arm, and well, I should say, so in your example, the tattoo data is being used in a way sort of against interest for Ben. We can also imagine that data being used for the interest for Ben, right?
Yes.
So the genetic information can be used to, if it's about the BRCA2 gene, it can be used to create therapeutics or preventative pharmaceuticals for cancer, for someone who has the BRCA2 gene. And Wojcicki was saying, before we do that, before we use your genetic data to pursue, and of course, they're also financially hugely attractive business opportunities. Before we do that, we always give the opportunity. I think it was even you have to opt in, and you can always opt out. And of course, that doesn't get to your point, right? And there you have, we've heard about these examples where the police are able to track people based on the genetic information that their relatives deposited in Ancestry or 23andMe. And so right, okay, so that's a great example of how contract law and kind of privacy law don't get at this and really have no way to talk about these externalities. But I want to, and maybe you also have a really nice example, which I think people will be familiar with, of the Ring doorbell, and how to the extent we're talking about harms from the horizontal data relationship, to the extent we're talking about harms and not benefits, these harms are not equally distributed, and in many cases, it's likely to be marginalized communities or people who are otherwise, especially online. It's women who are who are generally at the short end of the data analytics harmful consequences. So in your Ring doorbell example, you make that very clear. I decide to share my surveillance, Ring doorbell surveillance, with the police, and it's not. I, as a white woman, am less likely to be harmed by that sharing than a neighbor who's a Black woman or a Black family is, who is in a horizontal relationship with my data. Okay, but so now I want to, so privacy law, contract law, doesn't deal well with this. we do have environmental law. So you, like me, share an interest in it sounds like in sort of environmental law and sustainability. And this is, and I, in my reading, am becoming more and more intrigued, first of all, with how early they were talking about computer modeling and their deficits with respect to a complex adaptive ecosystem, right? And so, like, the idea that there are these interrelationships and codependencies, the notion that there are externalities and that, traditional nuisance law or litigation or, tort law was not well suited, was the reason why we got environmental regulation, right, in the 70s.
Right.
And so we, in like the information policy space, bring that up to say, like, Salome may consent to having her data like stripped out of her, right? Especially in your example of Adam, like if Adam, maybe he has no, political or social objection or interest in the collection at all. But if you pay him, he might accept, be willing to do that. And so, but we decided that, Salome doesn't get to accept payment to have her stream polluted, because there are downstream effects and there are ecosystem effects. So I guess my question to you is, how promising do you think that is? What can we learn from that in this context?
Yeah. So I'm that certainly, I think in that class of scholars that is very inspired by kind of the history of environmental regulation. And I think there are all kinds of lessons we can take from that. One being that the way that we and just as a quick pause, I really like your point about the fact that these sort of what I call these horizontal data relations. So the way that Adam and Ben both have an interest at stake in the tattoo data, that can be like a good interest for Ben, or it can be a bad interest for Ben. My point as a baseline is that there is an interest and we are not indexing it. Where I like the analogy to environmental regulation is that the way that we recognize that interest can take all kinds of forms. So some of that is just we create like a public agency and we say Salome can't decide how much pollution is okay in the stream because there are so many other people whose interests are at stake in the stream. We're going to create an environmental agency. They're going to monitor the water quality. It is up to them. They're going to set agency standards for what the water quality needs to be. And like, that's how we take care of it. But some of the other ways that an environmental agency sort of takes account for all of these sort of social interests is by creating licensing schemes, or by creating kind of like standards of operation that like producers of potentially environmental pollutants have to abide by. And other of their schemes are kind of like market floor raising schemes where they sort of introduce Energy Star ratings for like, AC units. And so, I think that once we recognize an expanded set of interests in the law, the toolkit that we have to sort of respond to that can be quite varied. And I think that it's important to take that lesson into any conversation about information governance, because, and here's where, externalities are a way of kind of capturing social effects. Social relations are just another kind of, intellectual tool that we can use to capture them. And why I like social relations is because it can differentiate between the ones, like we said, these externalities don't fall on us evenly. So some of these horizontal social relations are maybe not of a kind that we care that much about, but other of these horizontal social relations are materializing forms of social relation on the basis of race, or on the basis of sex, or on the basis of class, or on the basis of religious identity that we do care about. And because there's such a plurality of potential interests at stake, and sort of the legal quality of those interests at stake can vary a great deal, I think probably the legal responses required will also vary a great deal. So some of that might look like cities being able to put an API kind of licensing standard on sharing economy companies, saying if you want to operate in the city of Boston, you need to layer in this API. That data goes into kind of a pool that ride sharing workers can access. And so when they're sort of bargaining with the ride sharing companies, they also have access to the ride share data, and they can sort of do that bargaining on that basis. That's like a way of representing an interest in information that we don't currently kind of represent. A very different one is something like companies that collect a lot of valuable social data. They have 5 to 7 years to exploit that social data. And after 5 to 7 years, they either need to layer in technical specifications or fully hand over management of that social data to a research consortium or to the National Institute of Health that can then sort of allow people to write grants to gain access to that social data so we can understand it and sort of study it for sort of socially important research questions. Or maybe it's, after 5 to 7 years, we go through that data and a lot of it is really, valuable and dangerous and it just needs to be deleted, that there's like a time scale on how long that information is. That's also a way of recognizing an interest in information. So that's just a number of potential kind of ways that we could give expression to that. But I would absolutely underscore that I think that all of these tools need to be explored because of the variety of social relations and social interests at stake in information flows.
I really appreciate that distinction between externalities and social relations. That helps me understand the richness of the social relations concept. And it makes me think, in your example about the ride sharing data, something that I've been studying is the API, which is one of them is called the NDS, which is and so it's been a fascinating, and actually I think you really could contribute here. In the example that I'm studying, it was created by the Los Angeles Department of Transportation, and they were fed up with mostly Uber, but Uber and Lyft and the scooter companies, Lime and the others, they felt like these companies were kind of taking over the public rights of way, and it was an assertion, of civic public power to say your data has to come through us so that we can now tell you can't go on that street, and we noticed you're not serving this community and all of that. And so, I think the way I looked at it was what you're adding to it is that once that there is an API and there can be access to that data, why would you limit it to the municipality, right? Why wouldn't you also recognize that there are worker rights and that we have to have, access? We should consider access part of our social relations calculus. And I think that's really interesting. So when it first happened, I thought, good, this is like the city fighting back against private data accumulation. What I then saw happen was, it started to be viewed as a kind of scary government, big brother surveillance state move, right? That now the city of Los Angeles is going to be able to know where you go. And actually, I'm teaching a class tonight where I'm going to ask the students, are you more afraid of Uber's having your data or the city's having your data? And so I'll just, so I just throw that to you. I think, that's probably not the most helpful formulation of the question, right? Who are you most afraid of? How do we get out of that? Like, how do we move to this social relations friendly governance scheme?
Yeah, I mean, I think you put your finger on one of the thorniest questions that I certainly wrestle with in my work, and that I think my entire generation of legal scholars probably will have to wrestle with over the course of their legal careers and their intellectual careers, which is that, for a variety of historically and politically specific reasons, what we have in the United States right now is primarily a state that does one thing. And that one thing is or its general orientation to the citizenry is, one of enforcement and potentially coercion, especially depending on what social categories you are a member of. And we don't really have plenty of the examples that, for example, my European colleagues have. So if you were a German citizen during the pandemic, you could apply for COVID relief if you were a freelancer, if you worked in the creative industries. And I had a good friend who's a freelancer who lives in Berlin. She applied for COVID relief funds in the morning, and by 5 o'clock that evening, the German government had deposited that money directly into her bank account. Now, that requires a government that has access to all kinds of information about you, but it's being used to, in a seamless way, transfer money into her bank account. She doesn't have to prove who she is. They know who she is. She can just get the money. It's accessed. It's in her bank account. It's not coming in like a weird scammy looking credit card, which was how my COVID relief came when it finally did. I'm sure plenty of people accidentally threw away their COVID relief scammy looking fake debit card. And that's really a story.
You mentioned that Germany didn't always use data so beneficently.
Really didn't. And that's absolutely true. And that's the deep, profound problem that we have, which is that once you recognize that something is a problem that is larger than yourself, the way that that gets resolved can be extremely frightening and scary. And the way that that can get resolved is far more efficiently and effectively and kind of completely than we can do alone. And you know, we are now deep into the terrain of conversations about theories of the state, theories of democratic legitimacy, you know, how to appropriately balance the areas that we protect ourselves from the state from, and the areas where we recognize like this is only a problem we can solve together. As an information law scholar, I'm probably not going to resolve those problems. But what I can say is that I don't think we are well served as a theoretical matter by ignoring the fact that we have social and political stakes in our information production. So we can decide, for the LA city example, you know what? The risk of the LAPD getting a hold of this information is so great that it's just not worth doing the public intervention. That's balancing competing equities and coming down on one way. That's very different from saying we have no public stake in this information.
Absolutely.
And so I guess that's where I'm sort of am at it as an initial matter.
Yeah, that's a great point. So I want to save the end of our conversations. We're ending at 1:15, and I want to have so I invite everyone to, if you have a question, to put it in now. But one other before, and I also want to, Salome, talk about sort of your trajectory in the law and in your intellectual life. Just one other question before we get there, because we've sort of mentioned this, but I just wanted to spend a moment on it, about the relationship between datification and inequality. If you could just sort of sharpen that relationship up for us.
Yeah. So my kind of theory of datification and what makes it wrong is not that it is kind of like purely violating, you know, this relationship that I enjoy to my inner self and kind of violating that sense of autonomy I have, but literally that it materializes relations of social inequality, by which I mean that part of what makes the sort of data flow relation that Adam and Ben are in potentially oppressive and harmful is that it is materializing a relationship between a citizen and the state, the law enforcement, that we might view as sort of an unjust or unequal social relationship. And so that is kind of like my theory of what makes datification wrongful is not only that it's kind of like violating or threatening our autonomy, but also that it literally is materializing relations of social inequality. And so a lot of what that also, I think, better explains a lot of what it is that we're worried about when we worry about surveillance or data collection. So here I talk about the example about ICE collecting social movement data from people playing like mobile games on their phone. We might think that why we care about that information flow isn't that the people whose movement data has been collected are being spied on. Not only that, it is because that data flow to ICE is now enacting an unjust social relation, a relation of social inequality that sort of constitutes the kind of precarious social category of undocumented immigrants in this country.
Yeah, and I guess I would just add to that. So in the public sphere, those examples of power relationships and historic discrimination are maybe clearest, but it also is true in the private sphere. And so, many of our students will have, know of the sort of psychometric surveillance of bar takers or other exam takers. And so the personal affront that is an incomplete account of this is that your facial expressions are being used possibly to flag you as being a cheater or something like that. But it's also going into, in a horizontal data relationship way, it's going to inform the employers or the testing companies about whatever social group you're a part of. And so especially if you are part of a social group that is marginalized or otherwise has been disadvantaged by these companies and by the employers, you are sort of feeding into that. And so, and even if you consent, right, there are these downstream, or I think it's better to say horizontal harms.
And those are population level kind of things. So even if I'm not a member of the oppressed group, me doing the kind of activity that sets, for example, my credit score, helps to constitute those sorts of categories of association between credit scores and certain kinds of behavior. And if I'm a member of the sort of socially marginalized community, and I'm also using those things, I'm just as much sort of constituting those relations of association between certain types of behaviors and good credit. Again, these are sort of, we are all drafted into the project of one another's oppression. And that's what makes datification wrong. Being drafted into the project of one another's oppression, not just that it's sort of, violating my little island sphere of autonomy.
Right. Yeah, but the challenge is, everyone who wants to use their Fitbit, right, or everyone who wants to use their phone, they are all structured in this way that your data is in the cloud. So, we would need, and this is where I think we all come up, we sort of all founder a bit, is kind of where the, whether it's policy solutions or, I think just as probably kind of new business models and new norms, right? Because I think of this as kind of being like 1950s chemical industry, right? Like it just, or tobacco, right? Or littering, just like people chucking stuff out the window of their cars, right? Like that is what our Fitbit norms are right now. So.
And the response is that like all of these things need to change, How we got where we are as an environmental response is that we changed norms, we developed new business models, we developed public agencies, we expanded theories of litigation, yes, and,
Yes, exactly. All right, so Salome, talk a bit about, your trajectory, your law school career, and kind of what you did in the summers and after, and how you got here.
Yeah. So I think I mentioned briefly, so before coming to law school, I studied political economy and mathematics, and I then went to go get a graduate degree in the UK in economics, and I specifically was interested in the economics of social policy. I wanted to use data-driven insights to make the world a better place.
And at that point, you weren't going to go to law school, or you knew you would?
I was thinking about law school, so I took the LSAT my senior year, and I kind of was like, maybe I'll do a PhD in economics, maybe I'll go to law school. Five-year window on the LSAT back in my day. I hope that's still true. So I took the LSAT my senior year, and I went to the UK, and I really liked being an economist, but I realized that the best part of my day was when it's England. So at the end of the day, you meet your friends at the pub and people would say, what were you working on today? And my whole day, I was more or less alone cleaning data and running regression models. And at the end of the day, I actually got to talk about what it was I was studying. And I was looking a lot at how, even in the UK, which is a universal healthcare system, totally free, quality of health outcomes corresponded very closely to sort of marginalized social identities. So trying to understand what that is and what we could do in the healthcare system to sort of target or address that problem. And I love being able to talk about it. And I realized as a backdrop at that same time, and this is going to age me, was when all of the debates about the Affordable Health Care Act were going on in the United States. And I realized as a health economist, the numbers on like private provision of healthcare do not look good. The economic justification for the US healthcare system is very thin to non-existent. It's like climate change. The scientific consensus on how to do healthcare is just like really not the way the US does it. But that really didn't seem to matter for the arguments that were going on at all. And so for me, as a person who wanted to make an impact in the world, I realized like, you know, the economics alone, like having the empirical evidence is just really not enough. There are forms of advocacy that you kind of have to engage in on the basis of empirical evidence that my training as an economist really does not equip me to do at all. And so I decided to come back to the US. I went to law school here. And when I was here, I really got interested in consumer protection and kind of generally like questions of economic justice and where those met the law. So I did a lot of work on predatory lending, predatory student lending. And from there, from sort of the consumer protection, predatory lending work, I kind of found information and information privacy. Because so much of how people were being preyed on was in this very kind of targeted way. And that's kind of how I became interested in information and information technology and privacy law, was kind of through predatory lending and consumer protection work, which is what I did. So my first summer, and feel free to interrupt me if I've gone on too long or you want to ask a question about anything. But my first summer, I guess I shared the experience of a lot of 1Ls, which was like, if you want to do like social justice work in law school, you become a public defender. And I was like, well, I've never really done anything with criminal law, and I'm pretty sure I'm interested in the sort of economic, socioeconomic ways that people's opportunities are sort of constrained, or that prevent people from living kind of free and fulfilling lives. But like, why don't I just check out what this crim law thing is up to? And so I used my 1L year to kind of see if that was for me. I worked for an appellate public defense firm in New York City, my 1L year. And it was extremely fulfilling work. It was very interesting, but I learned that appellate work felt a lot like being an economist cleaning my data. I was not talking to people or advocating. That was sort of one thing. And I kind of also realized that I think particularly with my background in economics and a lot of the expertise I had in sort of social theory and economics, I really felt like my time and my talents were better used on the civil side of things. So it's not that I don't think criminal justice work isn't incredibly important. It's just that I think a whole lot of other people are better equipped to do it than me. And I kind of have this other skill set that works for this other equally important kind of area of law. So I used the 1L year to kind of tick that box. My second summer, I split between the law firm that I went to go practice at, which is a technology law firm. I was like, if I'm interested in this space, I want to get to know the industry. And a great way to do that is to go work at the law firms that work in that industry. So I spent half my summer there and half my summer at Los Angeles Legal Aid in their economic justice unit doing predatory lending work. And so those are sort of my 2 summers. Maybe I'll stop there. I'm happy to talk about what I did after law school as well.
Yeah, I mean, the thing, you know, when you talk about consumer protection, and I think this is a really hard thing for all of us in the law, and especially for students, is to think about, you know, what kind of tools do we have? This is the both end. We need litigation, we need new policy, and when we think about who our regulators are, right? So we have, you know, the Federal Trade Commission is who in the United States we turn to as a possible regulator in this space, and they are consumer protection. That's their mandate. And so, you know, and consumer protection is about individual autonomy and fairness to the individual. It really does not get at population harms or interests very well at all. So that's a challenge. Really, we need a new regulator with a new mandate, right? The Europeans have these, they do it as data protection, which is more on the dignitary harm side. I don't know if I'm asking you a question, but I'm just reflecting on, the way you got into this through consumer protection and how, that is fascinating and also limiting, right?
Absolutely. Yeah. I think that hopefully this resonates still with law, or maybe I hope it resonates less, but my experience with law was being simultaneously in law school was being sort of simultaneously blown away with how powerful law and sort of access to legal reasoning is as a tool of impact and empowerment, and how profoundly hemmed in you feel at the same moment with the confines of on what basis we can advance claims, on what basis things can be justiciable claims, things like that. So being like, this is so powerful and also so highly constrained.
Yeah.
I wanted to work, a lot of my work in the summer in LA was representing students whose for-profit college had basically, they had been targeted. They were monolingual Spanish speakers. They were targeted by a for-profit college that said that they would get Spanish language instruction. The school didn't even offer Spanish language instruction. The Department of Education actually shut them down for being fraudulent, yet many of these students were just still on the hook for thousands of dollars of federally backed student loans. Mm-hmm. And there was a very narrow basis on which I could try to get them at least just like some debt relief for the many thousands of dollars of student loans that they were on the hook for. Was any of them kind of the interconnecting nexus of, just predation that they had been subject to? No, it was like technicalities. You have to litigate on technicalities. Do I think it's still absolutely worthwhile to litigate on technicalities if the upside is someone can just, go through their life being slightly less burdened with slightly less debt? Like, yes, totally a worthwhile thing. I think part of law school too is learning how to kind of switch between making your like fundamental arguments of principle and being able to advance instrumental arguments. If getting someone out on a technicality or getting someone relief on a technicality on the basis of sort of conceptual commitments that I don't totally agree with is what will work, that's great. Can I simultaneously also entertain arguments about why that is an incomplete framework? Also, yes.
Yeah, and that's why we need you in the academy. I think we should close there and let everyone get back to classes and Zooms and all the rest. But Salome, thank you for joining us, and so excited to see what you write next and where you go from here.
Yeah, thank you. It was a real pleasure to join you all. I hope you all have a good rest of the day.
Okay, bye-bye.
Bye.